Magistrate Mr. C.I. Boswell, who happened to be a presiding magistrate at the said inquest. Magistrate C.I. Boswell wrote and communicated his opinions to the Secretary of Justice pursuant to a secret circular number 2 of 4th August 1967, advising as follows. I have to report that inquest proceedings in connection with the death of the above named Albert John Luthuli will be held at Stanger by me on the 19th September 1967 at 10 o'clock. From the reports available at present, I do not expect the finding to be one other than accidental death. I gather, however, that the cause of death, as furnished by the district surgeon, might be questioned by their relatives, but I cannot anticipate on what grounds the dispute is based. Close quote. This communique is from the person who would then preside over the inquest before hearing evidence. My lady, I have but to repeat that this communication predates the holding of the inquest, which was to be held on the 19th of September. And its contents indicate, without a shadow of a doubt, that the inquest magistrate had taken a decision before hearing evidence and or conducting investigations into the death of Chief Luthuli, as required by the Inquest Act 58 of 1959. My lady, an inquest is an investigatory process held in terms of the Inquest Act. The Act is primarily directed at establishing the cause of death of an individual where such is suspected of having died of other than natural causes. Section 16, subsection 2 of the Inquest Act requires a magistrate conducting an inquest to investigate and record his or her finding as to the identity of the deceased, the date of death, the cause or likely cause of the person's death. The magistrate must further record whether the death was brought about by any act or omission that prima facie amounts to an offense on the part of any person. The presiding officer is not called on to make a determinative finding as to the culpability. In performing the above functions, the magistrate has a duty to ensure that the investigations into the death of an individual is conducted thoroughly as pronounced by the court in the matter of Timor versus the magistrate of Joburg, wherein it was held. An inquest must be so thorough that the public and the interested parties are satisfied that there has been a full and fair investigation into the circumstances of the death. The appeal court in the Marais matter echoed the sentiments of the tomorrow case, wherein the court held as follows. The underlying purpose of an inquest is to promote public confidence and satisfaction, to reassure the public that all deaths from unnatural causes will receive proper attention and investigation, so that when necessary, appropriate measures can be taken to prevent similar occurrences, and so that persons responsible for such deaths may, as far as possible, be brought to justice. When the news broke of the death of Chief Albert Luthuli, many people within South Africa and internationally were deeply suspicious of the circumstances pertaining to his death. These suspicions continue for many years after his death. Many believed that the South African government of the day and its allies were responsible for the death of Chief Luthuli. Amongst those who believed that the death of Chief Luthuli was not caused by a train accident was a political activist and the founder of the 1960 Progressive Party, Mr. Christopher Rawlings. On the 2nd of July 2019, he submitted representations to the National Director of Public Prosecutions, Advocate Shamila Patel, calling for an investigation into the death of Chief Luthuli to be reopened. His request was also supported by the then Premier of KwaZulu-Natal, Mr. Willis Mchunu. Mr. Rawlings was of the opinion that the inquest court did not take into account certain scientific and mathematical evidence in reaching the above-mentioned conclusion. The National Prosecuting Authority, together with the Directorate of Priority Crimes Investigations, launched a fresh investigation into the death of Chief Luthuli. Upon completion of investigations, the Director of Public Prosecutions in KwaZulu-Natal requested the National Director of Public Prosecution to request, as she did, the Minister of Justice and Correctional Services, Mr. Ronald Ozi Lamola, in terms of Section 17, capital letter A, in brackets 1, of the Inquest Act 58 of 1959, to have the inquest into the death of Albert John Mvumbi Luthuli reopened. On the 13th of May 2024, after considering the submissions presented to him by the National Director of Public Prosecutions, Minister Lamola ordered that an inquest into the death of Albert John Mvumbi Luthuli be reopened. On the same date, Minister Lamola, in terms of Section 17, capital letter A, in brackets 1 of the Inquest Act, approached the Honorable Judge President of the KwaZulu-Natal Division of High Court, Judge President T.P. Poyorati, to designate a judge to preside over a reopened inquest into the death of Albert John Mvumbi Luthuli. My lady, at this juncture, I wish to take the court into the inquest proceedings of September 1967. My lady, this we are doing for a proper investigation into the death of Chief Luthuli. It is imperative for us to look at the evidence that was presented at the Inquest court to determine how the investigation was conducted. During the said proceedings, the following evidence and/or evidential material were placed before the Inquest court. Oral evidence and/or viva voce evidence. The evidence of Gregerson, Mary Gregerson, a medical practitioner and a senior superintendent at Stanger Hospital, who in her evidence in chief had to allude to what were their observations upon arrival of Chief Luthuli. In her evidence in chief, she merely confirmed an affidavit she deposed to on the 24th of July 1967 in respect of the death of Chief Luthuli, and that she at all material times was present when Mr. Joubert examined the patient. My lady, we are making this reference because the then Attorney General has made a decision that a formal inquest be held. During the inquest proceeding, instead of a witness testifying, reads out an affidavit. Whether such is in accordance with what the court has asked of a presiding officer, whether that is in accordance with what the Inquest Act enjoins a presiding officer to do, it is something which we will present evidence to and later on make our submissions about its appropriateness when an investigation is being conducted. My lady, it was only during cross-examination that this witness was able to give her opinion on the cause of death. That is, that the cause of death was due to head and chest injuries. It was at this stage that the witness alluded to a fracture of the skull, which was visible, and that she believed that the patient was thrown a distance because his clothing was torn and dirty. After the evidence of this witness, the prosecutor handed an affidavit of M.J. Joubert, a neurosurgeon of Devon, which was marked as Exhibit B, as the record of the said inquest proceedings will show, my lord, my lady, as they are part of the record of these proceedings. And in particular, the court might have a look at page 453, volume A. The next witness, who was equally called upon to confirm that he conducted a post-mortem examination on the body of an adult Bantu male, Albert John Luthuli, on the 21st of July 1967, and completed a report on Form Health 1, which was read and handed as Exhibit C, was Jacobus Johannes van Zyl. During cross-examination, the witness was asked whether from injuries he could be able to tell whether the deceased was struck from left or right. His response was, I quote, "There were multiple injuries, and it is impossible to say from which side, but I will say he was struck by some very heavy object to cause his injury." My lady, this is the least we know. From people who ought to have made the court wiser in terms of the injuries as per the narrative of an accident, whether the nature of injuries accords with the said narrative that the deceased was struck by a train. Now, on one's mind whether there was sufficient probing of the evidence of these witnesses about their observation of injuries, nature of the injuries, and the narrative that had been given. A look at the postmortem report, together with evidence of a pathologist that is still to give evidence before this court. The court will hear of the presence of injuries on the arms and hands of the deceased. However, during the initial inquest proceedings, no questions were led as to understand how the deceased could have sustained those injuries. How could a person who is struck by a train have injuries on the arms and hands? The court will hear the classification of the said injuries as defensive injuries. And then one would then wonder whether Chief Luthuli was defending himself against a train for him to sustain the injuries on the arms and the hands. Charles Baron Petrus Lewis, a detective sergeant in the South African Railway Police from Durban, an investigating officer of the case, was called to read as well his affidavit he deposed to on the 3rd of August 1967, which was received and marked Exhibit D. The same happened of Daniel Lezing-Reiling, who confirmed an affidavit that he deposed to on the 2nd of August 1967, which was later on marked Exhibit K. Peter Francois van Wyk was also called during those proceedings, and he confirmed equally an affidavit that he deposed to and was marked Exhibit L. Nsakani Mataba, who was working on the bridge within the vicinity of the alleged scene of an accident, was called to testify, and he inter alia testified that he saw the train when coming from Stenger, entering the bridge, but did not keep watching the train. As the train entered the bridge, it made a noise, but it was not blowing rather. It was traveling very fast. From the record, no evidence was solicited about Chief Luthuli. A number of affidavits were then handed up by the prosecutor. Those, my lady, were marked Exhibit O, that being the affidavit of Peter Francis Papaya. Exhibit B being an affidavit of Andreas Petrus Berger. Exhibit Q, an affidavit of Itich Kili. Exhibit R, an affidavit of Nokanya Luthuli. Exhibit S, an affidavit of N.S. Mfeka. Exhibit T, an affidavit of Zepi Gumede. My lady, Stephanus Albertus Latachan, who was the train driver that allegedly hit and caused the death of Chief Luthuli, was called to read an affidavit that he had deposed to on the 24th of July, 1967, to the South African Railway Police in Durban in connection with the death of a Bantu, Albert John Luthuli, which was received and marked Exhibit U. During cross-examination, after the reading of the affidavit, he told court that he first observed the deceased while he was 160 feet away from him, walking towards the train. He conceded that he did not slow down and was knocked down on the side of the engine. From the evidence that is referred to supra, can it be said that the Inquest court conducted an investigation into the death of Chief Luthuli in a manner that was so thorough that the public and interested parties were satisfied that there has been a full and fair investigation into the circumstances of the death? It is submitted a thorough investigation was not conducted at the court of court. Additional evidence will be tendered in these proceedings which may persuade the court to overturn the findings of the court of court. The prosecution will present the following evidence in persuading this honorable court to overturn the findings of the initial inquest court. we shall present the evidence of Frank Khamanyana, a member of the South African Police Service, who holds the rank of a captain, who will inter alia, who was inter alia able to trace the inquest record of 1967 and its annexure, as well as other evidential materials he secured. To follow on his footsteps would be Colonel Madimeta Johannes Montle, who took over the investigations from Captain Khamanyane. Colonel Montle secured the services of experts responsible for reconstruction and simulation of the scene. These experts are from Crime Scene Management Section of the South African Police Service. Colonel Montle also managed to track the whereabouts of a locomotive of a locomotive similar to that which was said to have caused the fatal accident of Chief Luthuli. My lady, for this, the court will refer to volume B and C, which talks to the reconstruction of the scene by Warrant Officer Brandon Craig Burgess of the National Crime Scene Management Unit. Similarly, the court will be referred to volume B and C, which relates to the simulation by Sunette Nell, who is a member of the South African Police Service attached to Local Criminal Record Center, Pretoria. My lady, A22, to which this court will be referred to, of volume B and C, relates to the locomotive similar to that which was said to have caused the fatal accident of Chief Luthuli and is in the custody of Leslie Charles Lapasrachne. Thomas Johannes Adolf Stein, a member of the South African Police Service, who holds the rank of a lieutenant colonel, who was part of the initial investigating team, continued with the investigations after Colonel Montle left their unit. During his evidence, he will inter alia in documents that has been recovered during investigations, such as the Department of Justice files containing volumes 1, 2, 3, and 4, uplifted from the National Archives. This court, my lady, shall hear of the family this court, my lady, shall hear evidence of the family members who will inter alia testify about his life, harassment, and persecutions they endured at the hands of the South African security agencies. These persons are, amongst others, his surviving daughter, Dr. Albertina Luthuli, his first grandson, Mr. Mtunzi Luthuli, his daughter-in-law, Miss Velamina Mary Luthuli, as well as Nozizwe Mhlongo Mabaso, who was close to the Luthuli family. The Honorable Jeffrey Tamsang Khadebe, Dr. Jabulani Mzalia and Mr. Brian Kaba will testify about Luthuli as a teacher, an anti-apartheid activist, the President General of the African National Congress, a traditional leader, and a Nobel Peace Prize recipient. The Honorable Jeffrey Tamzanga Khadebe will inter alia testify about how Luthuli, the President General of the ANC, was persecuted like many black South Africans who were opposed to the fascist system. His 1956 arrest, along with 156 others, for high treason, but was later released due to insufficient evidence to prosecute him. The numerous banning orders, which were designated to incapacitate the ANC and eliminate his influence within and outside the country. Honorable Khadebe will draw parallels between the death of Chief Luthuli and that of other African leaders. The state, my lady, will proceed to lead the evidence of Leslie Charles Labasrachner, a qualified steam locomotive driver and a custodian of a locomotive class 15CA, which is similar to the one alleged to have been involved in the accident which took the life of Chief Luthuli, who will inter alia testify about this class locomotive, its features, operational capabilities, as well as probabilities of inflicting the type of injuries referred to in Chief Luthuli's postmortem report. Charles van Tonder, a steam boiler maker employed at Roosevelt Rail, Capital Park, will inter alia testify about how this type of a locomotive operates, starting with rail worthiness of a locomotive before it embarks on a journey, its calibration and speed. He will also proffer his opinion on injuries which would likely be sustained by a person struck by the said train. Brendan Burgess, a warrant officer in the South African Police Service, stationed at the National Crime Scene Management Unit, where he is employed as a crime scene investigator and draftsman, whose core duties include videography, photography of crime scenes, forensic field work. He will testify about the reconstruction of the alleged accident scene, his findings, as well as the methodologies employed to arrive at the findings. In his evidence, he will further deal with probabilities relating to the evidence presented at the initial inquest proceedings by Mr. Latakhan, who was the train driver of the said Class 15CA locomotive that allegedly struck 36. This witness will further draw his findings and opinion based on mathematical and scientific calculations. This aspect will also enlighten this honorable court on why it is highly unlikely that Chief Luthuli was struck by a train and died as a result thereof. Sunet Nel, a member of the South African Police Service, holding the rank of a warrant officer and stationed at the Facial Identification Unit at the local Criminal Record Center, Pretoria, as a forensic artist and analyst, will testify about an artistic story of the scene images that were presented to her and further present her findings and or conclusions. Ms. Nell will present simulation with specific focus on inherent improbabilities contained in the evidence presented by witnesses at the initial inquest proceedings. During her evidence, she will testify about the probable causes pertaining to injuries sustained by the deceased. Hanif Majo, a retired outpatient clerk who at the relevant time was in the employ of the Department of Health in the said capacity and was stationed at Stenger Hospital, where the deceased died after he had been admitted. This witness will inter alia testify about how he happened to meet Chief Luthuli at Stenger Hospital on the 21st of July, 1967. Contrary to the evidence that was led during the initial inquest, this witness will tell court that the ambulance driver who drove to the scene to fetch the injured Chief Luthuli was not Peter Francis Papaya, who at the time was a transport superintendent for ambulances, but a certain Mr. Zwane. The state will further present the medical evidence of Dr. Sbusi Sonzele, a chief pathologist, KwaZulu-Natal. His medical expert opinion will not only show that the injuries sustained by the deceased could not have been caused by an impact of a moving train on a human body, but it will also shed light on the inadequate treatment that was offered to the deceased to perpetuate the ideology that proper and adequate health care could only be provided to persons of European descent. This was in line with the ideological matrix of a South African fascist system, which considered white people as a homogeneous group, superior in faith, intellect, force, and in law, compared to the indigenous African people who were considered inferior in every facet of life. Dr. Nzele, in his evidence, will also draw the court's attention to contradictions between oral evidence tendered during the initial inquest and the injuries recorded by the pathologists who conducted the medico-legal examination of the disease. For example, the court heard that the body of Mr. Luthuli was flung following an impact with a train. However, from the post-mortem report, there were no findings on the skin of the torso or the lower limbs which could favor the notion. Dr. Nzale will further give an opinion on injuries as recorded on the medical legal post-examination report, like the presence of bruises on the dorsal aspect of both the left and right hands of the deceased, as well as a fracture of the legs of the left proximal ulnar bone, which, according to him, signal defense injuries. He will also express opinion on injuries sustained by the deceased and the likelihood that such injuries were caused by a train accident. It is submitted that the evidence which the prosecution will lay during these proceedings was never placed before the court of court. Further, that the evidence presented during the said inquest proceedings was not I beg your pardon, my lady, that the evidence presented during the said inquest proceeding was inadequate for the court to arrive at a just finding. It is unfortunate that none of the witnesses who testified at the initial inquest proceedings could be traced. However, the inquest record and annexures thereto in the form of affidavits have been obtained and form part of the docket as per volume B. It is submitted that the evidence referred to supra it is submitted rather, my lady, that had the evidence referred to supra been presented to the court a core, the said inquest court would have arrived at a different conclusion relating to the death of Chief Luthuli. My lady, this is the state's summary of the evidence before this honorable court as it was presented then and will be presented during these proceedings, which we would argue at the end of these proceedings that there is merit not only in reopening the proceedings, but also of finding that there is reason to interfere with the finding of the initial inquest court. The first inquest was on the 19th of September 1967. Chief Luthuli died on the 21st of July. No further submissions, my lady. That would be all. My lady, at this stage, I would need a guidance from court, because now I am to hand over to one of my colleagues who will start to lead.
Yes, I need to make a ruling in terms of section 17, capital letter A, which is as follows, that the inquest into the death of Chief Albert Luthuli, held on the 19th of September 1967, is hereby reopened, and the state the prosecution is allowed to lead further evidence. And
yes, my lady, the time now is about 12:30. I'll hand over to Advocate Siabonga Humphrey Mobo
yes,
to call our first state witness.
yes, I have made the ruling that the DPP may proceed, the state may proceed.
That the inquest is reopened. Thank
beg-
you. That it is reopened.
Yes, I've already made that ruling.
Thank you.
As
Thank
to whether the previous inquest is set aside, I think that is the
Yes,
matter
that
that
will
will be
be
dealt with later.
determined as we go along.
So for the record, Advocate Siabonga Nobo is now going to lead the evidence of the first witness that is lined up for
As the-
today.
As the court pleases. I see it is 12:30. I do not anticipate that I will belong with the first witness, so may I ask leave to call him to the stand?
Yes, call the first witness to the
I
stand.
call Khodi Samang Frank Khamanyane.
Spell it.
If
for the
I
record.
think I've pronounced it correctly. It's Godisamang, Khodi Samang.
And the surname?
Khamanyane is Kgamanyane.
That's correct.
Yes, my registrar will swear him in.
As the court pleases.
Sir, do you have any objection to taking the prescribed oath?
No, maybe.
Can you please state your full names?
Pietermaritzburg, Frank Khamanyane.
Sir, do you swear that the evidence you are about to bring will be the truth, the whole truth, nothing but the truth? Please raise your right hand and repeat after me. I do so help you God.
I do so, please help me.
Swear in my name.
Thank you, Mr. Nobo.
As the court pleases, just as housekeeping, my lady, I understand the witness will testify in English. However, there may well be a need for an interpreter in the isiZulu language. I understand there should be one here in court.
Yes, do we have an interpreter? Mr. Nobo,
Yes, my lady.
I understand that we were allocated an interpreter,
Yes,
but Ms. Kupera, but apparently she left the court. Can we stand the matter down for her to be called back into court?
as the court
Yes,
pleases.
we'll take a short adjournment.
As the court pleases. I understand the rest. There is an interpreter.